What if I told you that the most powerful law in modern commerce is a law that most people never read, but everyone is living under? What if I told you that Article 9 doesn't make you sovereign, it shows you who already is? Banks use Article 9, corporations use Article 9, the wealthy use Article 9, but consumers, they never even heard of it. This is why people get confused when they talk about secured party creditor. They learned the poetry, but never learned the law. Thank y'all for watching this video. We got a lot to dive into. This is part 2 of my secured party creditor SPC series, where I help you understand and debunk the myths about the SPC and help you use it to your advantage. Okay? Article 9 runs commerce simply because it talks about secured transactions. What are secured transactions? Anything attached to collateral, your loans, your auto loans, your home. Okay? So this is a very important video. Make sure you stick around all the way to the end. I haven't did a video on Article 9 in a minute, so let's see how we are able to fill in some of those gaps now. Now, for those of you guys who don't know what Article 9 is, Article 9 is on the secured transaction. So thank y'all for watching this video. Let's dive into another one. Article 9 is the part of the UCC that governs secure transactions. It's not magic, it's not secret, it's not hidden. It's the rule book for how claims, collateral, and priority works. If you understand Article 9, you understand power. So when you go to Cornell.law, Article 9, secure transactions, you did what I'm saying? Everything is right here, right? And I bring this up and I want to show you guys this whole section because you got this whole section. Specifically, if I wanted to go to Article 9-210, this specifically what backs up the argument of challenging and asking them for the accounting statements. Okay? So this is power. This is when you can actually exercise and challenge and ask them to provide authenticated records of their accounting. Okay? So if you want this type of clarity without confusion, this is why I built the Fund Yourself Academy inside of the school. The Fund Yourself Academy is where I break down the UCC, structure, documentation, and remedy step by step. So you can operate like the creditor in the system built for debtors. If you're tired of guessing and ready for structure, the link is below. Now, let's keep going. Here's where people get it wrong. A creditor isn't defined by ownership. A creditor is defined by control. Article 9 says this clearly. The party who controls the collateral controls the claim. You guys gather that. This is why banks don't need to own anything. They just need a security interest on it. What is security interest? A security interest is the legal right granted by a borrower to a lender that gives the lender the ability to take a borrower's property if they fail to repay a loan. This interest secures a payment for a loan and protects the lender's investment. Common examples include mortgage on a house, deed of a trust on a car, which allows the lender to repossess and sell the property if the borrower defaults. So the security interest really is just the element of control. It's not that they own it because they are servicers and they don't own it. Those investors own it. Maybe the United States own it. But the ownership aspect is irrelevant. It's overrated. Control is everything. If you have control over it, then that's really all you need. So this is why trusts really do help effectively, because you can have control without having ownership over something. Okay? What secured actually means in law. Secured doesn't mean sovereign. It doesn't mean a special status. It doesn't mean your name is in gold letters somewhere. Some of us think that they get obsessed over, should I write this in blue ink or red ink or whatever the case may be. By all means, write it in blue, red. I would prefer you to write it in blue ink or red ink. But it's all about the wet ink signature. Like, if you say you signed it and it got authenticated in a notary, then it doesn't matter how you did it, okay? Secure means one thing, that your interest has priority over others because you documented it properly. That's it. Simple, lawful, and powerful. That's what security or secured means. It's almost like confident, right? Y'all know I'm always bring it back to real life. When you actually do your documentation, when you are communicating with a debt collector, that is moving like a secured party creditor. You send a letter asking for clarification. Based on the clarification, you ask them to correct whatever they clarify. If they do not correct it, then you escalate. You document and you escalate. That's how a secured party creditor moves. Okay? It's the same as being sovereign. A sovereign is a person who is aware of the system, not someone who wants to beat the system. You know what I mean? So here's how the banks use Article 9 against you without even saying a word. They'll file a UCC-1 financing statement to secure their interests. That public filing says, we have the first position on this collateral. So essentially, if anything goes through this company, or if anything goes to this collateral, you basically have to come through me. So when you file a UCC-1, it's essentially saying like, your name is attached to it. So to make it plain and simple, a UCC-1 is just a public notice form. It puts the public on notice about something. That's it. It tells the world, hey, this person or business has claim on this collateral. That's what gives security interest. Okay? Nothing more, nothing mystical, nothing sovereign, and nothing secret. It works like this. A lender gives someone money or value. Number 2, they want to protect their interest in the item that they finance, car, equipment, inventory, business assets. So they file the UCC-1. This puts everyone on notice that if the borrower stops paying, we get first rights to the collateral. Think of it like dibs. I got dibs on you. Whoever files first gets priority. What the UCC-1 does, it protects the lender's interests. It establishes priority over creditors. It makes security interest public, and it helps in repossession and liquidation if needed. UCC-1 doesn't make you sovereign. It doesn't erase debt. It doesn't create secret accounts. It doesn't give you special legal status. It doesn't free you from the government or contracts, and it doesn't magically make you a secured party creditor. It requires real transaction, real collateral, and real separation. Here's the real truth. A UCC-1 is not a magic wand. It's a business tool. And the banks use it every single day to secure their interests. If you want to do it, if you want to use it, you're going to have to do the same thing that they do. You're going to have structure. You're going to have a trust, entities, real agreements, real collateral, real documentation. That's the power, not the form itself. Okay? I'll do a diagram, and I may put it in the school community, but I want you to understand that they don't hide it. They don't debate it. They just execute it through structure. They do the structure because they're going to fall on the side of whoever's more structured. Okay? Meanwhile, consumers are online claiming titles that they can't support with no structure and no collateral. You go into court and say you're a secured party creditor because somebody online told you that you should be saying that. But did you actually do the research? Are you aware of the system? That is a secured party creditor, somebody who is aware, someone who knows what the bank did so that they know how to go back and combat that. So there's a difference in the way that a consumer moves versus how a bank moves. But this is how I would move. As a secured party creditor that hasn't filed any form. As a sovereign person who hasn't filed any forms. Okay? If I wanted to challenge a UCC-1 in a debt discharge battle, and I may do a video on this, but I'm going to make sure to not attack the UCC-1 form itself. I'm going to attack the foundation of the security interest. The security interest is only valid if the creditor can prove that there is a real agreement. There must be a legitimate contract showing that I granted them security interest. Number 2, they should have rights to the collateral. They must show what collateral they actually have a claim to. Number 3, the value given. They must prove value was actually provided to support the security interest, performance, funding, and documented consideration. And proper perfection. The filing must match the debtor's name, collateral description, and transaction. See, this is the strategy. You challenge the elements, not really the form. Okay? In essence, show me the agreement, the collateral, and the value that was created, that created the security interest that you are claiming. If they cannot prove one of these, then the security interest is defective. If the security interest is defective, their priority collapses. So when their priority collapses, you gain leverage for debt discharge, correction, or settlement. If they cannot prove the claim, then they cannot enforce the chain. It is just that simple. And because of that knowledge right there is exactly why I would say, hey, look, secured party creditor, you can fill out forms, but if you don't even understand how to strategize against a situation like that, then no, it doesn't matter if you do a form. You could be labeled as a secure party creditor, but if you cannot challenge their security interests, then you're going to lose the battle. All right? So why filing it on yourself does nothing. Okay? This piece of information is so important. People teach online that you can file a UCC-1 against your own name and magically become a secure party creditor. But here's the problem. A valid security interest requires an agreement, rights in the collateral, value given, and proper filing. You can't secure something you don't have a real agreement with. And you can't be both the debtor and the creditor with no separation. This is why structure matters. Trust, entities, and documentation. These create the separation needed for real security interests. Now, here's the true power. How you become the creditor through structure. You operate as a real secure party creditor. You don't need structure, or as a matter of fact, you need structure, not symbolism. When you build trust layers, business entities, understand internal banking principles, you can then create real agreements with real separation and real collateral control. Okay? That's what the wealthy families do. That's what the banks do. And that's what sovereign individuals learn to do. It's nothing about paperwork. It's nothing about doing something new. They just become more aware of the system and they actually start playing the system and how the system needs to be played. Not doing what somebody tells you to do, but literally finding it out for yourself and doing what you understand is in your best interest. But you can't really make calculated decisions without doing the educated research before you make that decision. And watching this YouTube video is not the only place. All right? A secure party creditor isn't a title. It's a position earned through structure. So if you want to position yourself, you got to think about this. To make this plain and simple. Secure party creditor works on his credit, challenges credit bureaus, challenges debt collectors, challenges loans. Actually is trying to build wealth, reach that $10 million mark, or whatever the case may be, do the best that they can so that they can be able to set their family up for life. It's not going to be you become a secure party creditor and you never have to pay a debt. You never have to do this stuff again. You got to get that out your mind. All right? It's going to take some work. It's going to take some value. You're going to have to bring value. You don't get paid for what you do. You get paid for the value that you bring. And what if I told you that if you understand how to build your value, forget the SPC status, forget a sovereign citizen status, you can be able to create anything you want out of this lifestyle if you understand your value, you know how to extract it for yourself. Some of us give our value away to these banks and all of that, but forget that. A lot of us give our value away to our job. We give our value away to other people. And never put that value into ourselves. Never invest that value into ourselves. And today I'm trying to tell you that in order to be, if you want to be a secure party creditor, it's going to be on understanding your value and using your value. Doing what it is that you feel like and know you need to do. Being emotionless in the face of adversity. Well, not emotionless, but, not react with your emotion. Understanding and moving proactive. All right? So we broke down the UCC filings and we're going to dive into a little bit more in my next video. But this video specifically talks about Article 9 and UCC-1 really goes in hand with that. So thank y'all for watching the video. I love y'all. And if you're done consuming and ready to create your own system, tap into the Fund Yourself Academy. Tap into the Fund Yourself Academy because we are breaking down and help you understand the articles. And at the end of this series, I might put together a workbook to bring this all together so that you can physically read it and you don't have to sit here and watch the video, but that's only going to be in the school community. So tap into the school community. Also, if you want to work with me one-on-one, specifically on your credit, specifically on your debt and understanding that, tap into the mentorship link down below. Apply to work with us. But other than that, thank y'all for watching the video. I love y'all and I'll see you on the next one.